Hello, everyone, and welcome to this session 2 of the Privacy Rules Privacyespresso on data transfer in and out of Hong Kong. We discussed in our previous session about data imports, so data coming into Hong Kong. We discussed with Pàdraig Walsh about the impact of the Schrems 2 case at the international level, but in particular, of course, in exchanging data with Hong Kong. And today I'm again with our expert, Pàdraig Walsh from the law firm Tanner DeWitt in Hong Kong, in order to discuss this topic under the opposite perspective, that is the one of data exports. In that regard, I think that the best thing to do would be, first of all, to understand, what's the framework in Hong Kong. So, Pàdraig, is there, first of all, any statutory framework in Hong Kong in relation to this aspect?
Well, it's an interesting question, Alessandro, for this reason. There is a statutory framework, but it's not in force. So let me give you the story behind it, because it's in some ways, it's a fascinating story. So Hong Kong has one of the longest track records for a piece of legislation addressing personal data in Asia. It dates back to the mid to late 1990s. Now, within that piece of legislation, there is a statutory provision, it's Section 33, which provides a framework that is broadly similar, not as detailed and not as maybe modern as the adequacy assessment framework that's within GDPR, but it's conceptually very much the same. The idea that you can transfer personal data from Hong Kong to other locations if those locations are on a white list of approved countries or jurisdictions. But for other circumstances, you have to have certain safeguards in respect of how you deal with the transfer of personal data. But here's the thing, it's not in force yet. So it's on the books, but if you fast forward from 1996 to 2023, it's still not in force. So there isn't a statutory and framework in force in Hong Kong in respect of international data transfers.
And I understand why it's a funny story, but it's extremely interesting, because the aspect you were proposing was about something that would have been basically aligned to what is required, for example, in the EU. But listening to you, my next question would be: so, is there any law or any way in which data transfer are regulated there?
Yes, and this is, I guess, the next misunderstanding that might arise once you appreciate that Section 33 isn't in force. It doesn't mean that there is no regulation in respect of the transfer of personal data from Hong Kong to other locations. It's more that the regulation arises by virtue of the principles that are already embedded within our privacy legislation. Let me explain this. The basic principle behind the use of personal data in Hong Kong is that you inform the data subject on or before the collection of the personal data of the purposes for which the personal data will be used and the classes of persons to whom the personal data may be transferred. Now, the PCPD, the privacy regulator in Hong Kong, has published guidance that has made it clear that the transfer of personal data, including transfer of personal data out of Hong Kong, is a form of use, which means that if you are going to transfer personal data outside of Hong Kong, then it is one of the subject matter that must be addressed in the personal information collection statement. And if you don't do so, then you are in breach of those obligations in respect of the data protection principles that are enshrined in the Personal Data Privacy Ordinance. So in that sense, although there is no express statutory requirement, there is a regulatory framework embedded in the data protection principles that are a core part of the privacy ordinance and privacy legislation in Hong Kong. Now, what that means in practice is that businesses should look at their privacy policies and their collection statements to make sure that they are addressing circumstances in which the personal data will be transferred to other locations and the persons to whom they should be transferring, or they will be transferring personal data, and classifying how they are going about, firstly, disclosing that, and then secondly, complying with and fulfilling the other obligations in respect of the personal data in question, among which would be the security of the personal data, particularly if they transfers to data processors elsewhere, and data retention principles in respect of the length of time for which any transferee may hold on to the personal data. So those particular requirements are the kinds of requirements that businesses should pay attention to and seek to protect by things like adopting recommended model clauses that the that the PCPD has published in Hong Kong in data processing agreements and data sharing agreements.
Perfect, Pádraig, and that makes me, raised me into my mind another question that is related to, when you export data under the practical point of view, how do you do that? Which kind of agreement do you put in place? Do you have, data processing, data sharing agreements? How does it work under the practical point of view in your experience? Or should work, basically?
I will tell you what the best practice would be, which is that you would firstly analyze the data that is the subject of the data transfer itself. You would analyze the role of the person who's receiving that data on the other side, and you would put in place either an agreement or a schedule to agreement that deals with the data privacy and protection obligations related to that transfer. And it's slightly different if the person you're transferring to is a data user or a data controller in GDPR terms, or to a data processor. So there's a contractual side to that. Now, the PCPD has published model clauses that are recommended to be used in those circumstances, not unlike what has happened under GDPR. What you tend to find is two things. One is that an agreement is not necessarily always put in place with either those provisions or at least some provisions that properly deal with data privacy and protection obligations. I don't think it is as common or prevalent a practice in Hong Kong as it would be within the EU, for instance. And secondly, if you look at other measures that should be put in place, frequently there isn't the same degree of probity or scrutiny that's given to things like due diligence on the transferee, reviews and audits in respect of how data transfer processes are progressing. Now, I say that in a general sense. Some sectors are better than other sectors. They tend to be, if you're within a regulated sector, for instance, like financial services or something that's related to medical personal data, then the processes tend to be rather robust and strong. But if you're a business outside of those sectors, then it's a bit more haphazard and sketchy in respect of adhering to those best practices.
Perfect. Pádraig, thanks a lot, because we are running out of our time, but thanks a lot for giving us this overview on data transfer in two sessions. This is the second one, so I would like to invite our listeners, if they didn't, to also go through the first one that will appear here as a link. Pádraig, thanks a lot for being with us. Thanks a lot to our audience again for following us, and looking forward to meet you all with the next Privacy Espresso. So bye, Pádraig, and bye, everyone.